Thank you. Okay, thank you. Good afternoon, ladies and gentlemen. My name is Nicholas T. I'm going to be doing this webinar. I see that 16 people have tuned in out of the 25 who were scheduled to tune in. If you're looking at your screens on the right, you should have a place where you can type questions. I think I'll give people about another 2 minutes before launching into the actual webinar. May I just ask Amu, if you, right at the top of the list, can say that you can hear me, just type yes. Then Anna-Marie, just type yes and send. Barbara, Bonginkosi, Brenda, Francois, and Francois. Okay, so far I've got yeses across the board. Grace. All right. Golofelo. Thank you. Magda. Marius. Marlene. You seem to be missing at the moment. Ntombi. Penny and Tanya. Tanya, are you there? Okay, thank you very much. Ladies and gentlemen, I'm going to start now, and those who are late will be able to catch up on the following basis. The first thing that we're doing is this webinar is going to be recorded. At the end of the webinar, what I'm going to ask for is a transcript of it, in the sense that they're going to give me a physical recording of it, which I will have typed. And then after the typing, what I'm going to do is I'm going to edit it, and then I'm going to put in all the footnotes, the cross-references, and so on, to a very vast amount of research that has gone into this webinar, so that you don't have to sit there with a pen and paper and take down all sorts of unnecessary details at the moment. I'm hoping to be able to send that to you by latest the end of September, so don't think about it in August. Now, in this overview, what I want to explain is how this webinar is going to work. I'll be speaking until about 5 o'clock. Around then, we'll probably have a comfort break, at which stage it will also give you a chance to type any questions that you would like me to deal with specifically. The very important feature of this webinar is that it deals with two facets. It deals with land reform and land claims. Now, I believe you've had a seminar and it dealt primarily with the land claim facet and not the land reform facet. Questions that have come into the Law Society before this have dealt with the main elephant in the room, and the elephant in the room is expropriation without compensation, and I was asked whether I would deal with that. Well, in fact, I think that is the central feature of this entire webinar, and I'm going to start with it by centering it around Section 25 of the Constitution. Later, I'll touch on Section 26, and what I'm going to do is to follow the text of the Constitution and then refer it back to the past laws, the current law, and the future of what our law will probably become in terms of the reforms which inevitably are going to be coming through. Now, I want to say something to lawyers particularly, and I assume that you're all lawyers. We are the people who have to keep calm. This entire facet of land debate is the most hideously divisive, or if you want the older way of saying it, divisive feature in the land at the moment. It's also filled with a lot of polemic, which is completely unnecessary. And for lawyers, you don't need the polemic. You need an understanding and a practical understanding of how you are going to be able to deal with these questions so that you are in a position in your practice to be able to give objective, accurate, and impartial advice that does not undermine the Constitution. So on your screen, you will see an Encyclopedia Britannica map, and that's where I'm going to start. You will have received this morning the Constitution of the Republic of South Africa 1996 Bill of Rights, section 25 on property, 26 on housing, and the limitations. So keep that near you because we'll cross-refer. This map represents more or less the final state of what used to be called the Bantustans and then later homelands inside South Africa as just before, and that is just before the transition in 1994. Now, any objective observer who looks at this map will notice that there's a very interesting feature about where the homelands were situated. And the homelands were generally situated, as you can see with the Eastern Cape and KwaZulu-Natal, along quite a reasonably good arable area. Also, an objective observer looking at this map will see that there are virtually no homelands at all to the very western part of the country. And that, of course, is simply because there were fewer people there to make any form of a homeland viable in terms of the National Party policy which they were trying to engage in. Now, that homeland area that you see constitutes approximately 14% of the surface area of South Africa. However, when you look at the location of the homelands, the land actually, objectively, is not as bad as people would think. So those areas actually do contain some arable lands. Now, the reason why they became unviable is because they were overpopulated. And the reason they're overpopulated is part and parcel of why we are here talking about land today. So what I would like you to do now is to have a look at this next slide. This is an overview of what we're going to be dealing with today. Now, I haven't put in the pre-colonial, the pre-Union of South Africa legislation because there's too much. I will deal with that in a few minutes. But if you look at the top line, you'll see the Union of South Africa came into being on the 31st of May 1910. It had been established by an Act of Parliament in Westminster in London called the South Africa Act in 1909. But the actual start date of the Union was the 31st of May 1910. Now, in this country, the 31st of May had a particular resonance for two groups of white people. Those two groups of white people were the Dutch descendants and the English, and technically the British. The reason being, the Second Anglo-Boer War terminated on the 31st of May, 1902. So remember that date, 31 May. Now, for all of you who've ever traveled to Pretoria or to Bloemfontein or down to Cape Town, you will have seen the statue before the Union buildings of a horse and two men on each side. That is the statue of Castor and Pollux. They are the Gemini twins. Gemini is the Greek and the Latin for that was Dioscuri. Gemini is the 31st of May. The representation before Parliament that you see there comes from Herbert Baker, and he hoped that the Union buildings would see to the unification of the English language groups and the Afrikaans language groups in South Africa. The purpose of that union was to strengthen white power and to consolidate white power in order to control black people in the country. Unfortunately, it's as ruthlessly frank as that. So, after the Union started in 1913 was the first Natives Land Act. Later on, and we'll see it when we get to more documents, the word natives became an inherent contradiction for the so-called Europeans who were running the show. So they changed it to Bantu. Then still later, they changed that to black, and in some of the legislation to the word plural. We'll get to that later. Now, the next step you see there is in 1927, the Immorality Act outlawed um, sexual relations between white people and black people. The very first statute that outlawed that was 1683, one by Simon van der Stel in the Cape. So this is in the same long line of that sort of tradition. The next was the 1927 Natives Administration Act. Then there was the 1931 Blacklands Adjustment Act. And then there was a further release. There was the John Donne. And then the big one of the 1936 Native and later Bantu, later Black, later South African Development Trust Land Act. Now let me just focus on the 1913 and 36 Acts. In 1913, approximately 7.5% of South Africa was isolated and put under what they called reserves. This was typical British colonial policy. It copycatted what they'd done in Canada, what they'd done in Australia, and various other places around the world. So there was nothing at the time unusual about reserving for the natives. Now, in Australia, the natives were referred to as Aboriginals, but here they were referred to as natives. That 7.5% which was reserved meant, if you understand arithmetic, that 92.5% was already in white hands. So in other words, the Union controlled the whole, but reserved 7.5% for black people. All the other black people living around anywhere inside the rest of the structure of the Union were living precariously. In 1936, a couple of percentage points were added, approximately 6.5%, and so it tended to be around about 13 to 14%. At the moment, according to the research, it seems to be about 18%, but we will get to that in due course because there's a lot of contention about the percentage. So now, when you have a system that reserves so much land for so few and so little land for so many, you clearly have an intrinsically unstable system for the future. You will see then farther down the page, 1948 began the apartheid policy on race relations. Now, this is also objectively something we must be careful of. People blame the Afrikaans community for the apartheid policy. But if you look up that list, you will see very important features of the United Party government, which was a general party, including particularly first language English speakers, who were responsible for the 36 Act, the 37, which is the Deeds Registries Act, which we still use today, the Provincial Powers Extension Act, the Natives Urban Areas Consolidation Act, which was the centerpiece later of apartheid legislation, and that was in 1945. And the biggest irony of that, 1945 was the end of the Second World War, which South Africa had joined to fight the Nazis, and yet we were embarking on a more and more race-based policy. Now, once apartheid started, again, there was an immediate prohibition of mixed marriages. There was the population register. There was the group areas, and the group areas act was primarily aimed at moving colored people and Indian people out of so-called black spots in white areas. Then 1952 was the really silly named act. It was the Natives Abolition of Passes and Coordination of Documents Act, whereby the National Party extended the use of passes to women, because before that it had only been applied to men. Then you had the Black Education Act, and you can see the list of acts gets down and gets more and more extensive as apartheid starts to bite. The, the other misnomer is the 1959 Act called Extension of University of Education Act, where people, where the universities were split in terms of race. Now I'm going to move to the next slide. Then in 1961, again the 31st of May, South Africa became a republic. Now, most importantly about this is that South Africa had received general independence from Great Britain, surprise, surprise, by the Statute of Westminster, which began operation in 1931, which was 30 years before that date. So in fact, South Africa was completely legally independent of Britain even before the Republic was proclaimed. And then you can see that the Republicans, that is the white ruling class, started to get a bit queasy about the use of the word natives. So in the 1964 Act, they moved from calling natives natives to calling natives Bantu. And then later on, there was a change again in 1978 to call Bantu blacks, and that's when you got these departments of plural affairs and so on, which is another word which was sometimes used to describe black people. The next step that leads us to the land issues today is that in 1983, there was a sea change of apartheid, in the sense that P.W. Botha and his government tried to change apartheid from hitherto having been whites versus non-whites to blacks versus non-blacks, where coloureds and Indians were given separate houses of parliament. So the idea was to try and isolate the African black people and to create a much larger controlling body of whites, coloureds and Indians. Of course, that spawned the foundation of the United Democratic Front in August of 1983. That constitution came into operation in November 1983. And then the two acts that are so interestingly different. 1984, the Black Communities Development Act was designed to try to continue to hold apartheid in its place, and basically not only the spatial planning of the cities, which we'll deal with later, but also of the country. But in 1984, the first of the really big demonstrations against apartheid after 1976 began again in the area of Sebokeng. And from then onwards, there was a deliberate policy to make townships ungovernable. By 1988, the security cluster under P.W. Botha was in such a mess that they decided that what they wanted to do to try and calm things down in the townships where black people were living under leasehold to the municipalities was to transfer the leasehold to ownership under the preconception that if somebody owns the house they live in, they'll stop throwing stones at the soldiers. As you know, that didn't happen. Then there was a change of government inside the National Party, and to everybody's surprise, F.W. de Klerk unbanned the African National Congress, the South African Communist Party, the Congress of Trade Union, and a whole lot of other political parties as well, and then freed Nelson Mandela. And at that stage, we can mark the beginning of the negotiations for a democratic constitution. In 1991, just before the first sitting of CODESA, an act of parliament came out, and we'll look at it later because it is quite a sad, it's a good thing that happened for South Africa, but it's a sad reflection of what had gone on in the past, and it was called the Abolition of Racially Based Land Measures Act. Then there was the first upgrading of land tenure rights, and that is an important indicator of what people realized at the time was the core problem South Africa was going to face. And the core problem is the distribution of land, be it in rural areas, peri-urban, or urban areas. And the last one to point out there is the 1994 KwaZulu-Natal Ingonyama Trust Act. Believe it or not, that act was passed on Monday, the 25th of April in Parliament, with a retrospective commencement date of Sunday, the 24th. And that was done just before the interim constitution, which is above it, Constitution Act 200 of 1993, came into operation. So what is this lecture in the sense of this webinar about? The very top is the research done by Professor W.J. du Plessis from Potchefstroom University, now called the University of the Northwest. Now, she is a brilliant scholar. She's a very young woman, and her name is Wilhelmina Jacoba, also known as Elmine. And she found that by the time of the advent of the new South Africa, about 17,000 statutory measures had been issued to segregate and control land division, with 14 different land control systems in South Africa. So we are dealing with that legacy even to this day. We are the lawyers. We've got to keep people calm, and we have got to make sure that this whole debate doesn't turn out into a completely unresolved fight on the streets. And the only way to do it is we're going to have to look at how it can be done. Now, the interim constitution kicked into force on the 27th of April 1994. Then, particularly through 1996, both houses of parliament met to thrash out what we used to euphemistically call the final constitution. Obviously, it's not the final constitution because, as you know, our constitution has already had 17 amendments. But eventually, they were ready to present what they called the draft final constitution to the Constitutional Court for its approval. The Constitutional Court had to certify it in terms of the interim constitution. Then the Constitutional Court in December gave its judgment and said that there were a few things that needed to be changed, and they had to be done within 3 months. The final constitutional certification judgment was delivered on the 4th of February 1997. So on the 4th of February 1997, the Constitution 1996 came into full force. So although it's a 96 Constitution, it starts operation from the 4th of February 97. Now, the 5th Constitutional Law Amendment Act changed the name of the Constitution from Act 108 of 1996 to the Constitution and then a comma 1996. So we no longer refer to the Act as Act 108 of 1996, except of course if you're using Jutastat, because it's much quicker to search for the Act that way. Now, inside our Constitution at the moment, Section 25 is the core of what I'm going to be dealing with. But the core of what I'm going to be dealing with is broken up into 3 subsections. So you will see there, Ben Cousins calls the 25.5 land redistribution, and 25.6, the land tenure reform, and that's vast, and then 25.7, land restitution. So let's start at that end. The land restitution operates from 19 June to today. In other words, any people who are dispossessed of their property through racially discriminatory laws from 19 June until today, even today, are entitled to restitution provided that they can prove their rights within Act 22 of 1994. And as you can see, it was passed pretty soon after the after the commencement of the Constitution. Now, unfortunately, there were other people who needed security of tenure, and they were called labor tenants. And these labor tenants had worked on farms owned by, particularly in KwaZulu-Natal, very rich Englishmen who'd come out from Britain, and in the Transvaal by some reasonably wealthy um, Dutch people whose wealth was destroyed during the Second Anglo-Boer War and then had to be reconstituted during the period from 1902 to 1910. And these people used to live on the farms, and they would do a little bit of work for the farm owner, but mainly they would look after their own crops and they would have their own animals. And these were the labor tenants. Often they were semi-seasonal as well. The problem was how to give them rights without giving them ownership rights, because it was not regarded as a politically expedient idea in 94 to start expropriating those lands. And the compromise that was dealt with was a very simple compromise. It would declare land reform labor tenants to have servitudes over the land, and those servitudes would be in perpetuity. So in effect, it would achieve, without taking the land ownership away from the farmer, it would achieve basically the same thing. However, and this is where, as lawyers, we really have to be careful of our moral duties, particularly now. The tragedy of what happened. The tragedy is this. The Land Reform Labor Tenants Bill was published for the first time roundabout, and I'm going to have to confirm this with you because I haven't been able to find the original publication, but it was around about January 1995. And it was a bill. Now, as you know, a bill has to go through various readings in Parliament before ultimately it gets passed and then assented to by the President. And in the bill, there was a definition of labor tenants, and there was a definition of farm worker. And the definition of labor tenant, which is quite an elaborate definition, ended by excluding farm worker. Now, clever lawyers working for the farmers went out to the farmers and said, look, people, if those people living on the side of your farm are actually labor tenants, when this bill is passed, you're going to have to give them that land in perpetuity under servitude. But if they are farm workers, then they cannot be labor tenants in terms of the bill. So what happened is hundreds and hundreds of farms and farmers went around, inverted commas, employing the labor tenants under employment contracts. Most of those people could actually not read. So the way in which they got them to mark their agreement to the contract of employment as a farm worker was to mark an X, or better still, was a thumbprint. And that is how approximately, it's difficult to know, but a couple of 100,000 people were then moved before the bill became law from labor tenants to farm workers. When we raised these problems in the High Court in 1997 and onwards, a lot of the judges were very conservative and were not prepared to apply Section 30 of the Land Rights Act dealing with evidence to actually bypass the difficulty of an ex post facto change to the actual status of labor tenants. And so we now know from the research done in the Western Cape, particularly by Plaas and Cousins and Dr. Ruth Hall and Aninka Claessens, that between 1994 and 2004, 940,000 people were evicted off the farms. And what had happened is they were given these contracts as a farm worker for a couple of years. They clearly, inverted commas, were not labor tenants. And when their couple of years were up, the farmers would ask the people to leave the farm. And then sometimes would actually chase them off the farm. Now, people, we are facing the difficulties that were caused by um, that abuse of the process of the law, and we are the lawyers. We can't allow that to happen again in the reform that is coming now. What I would like also to say is that obviously the government realized something was going wrong. And at that point, the government then put in the interim protection of informal land rights, but it still didn't stem the flow. And then they put in the extension of security of tenure Act 62 of 97, which is ESTA, and that also didn't stem the flow. In fact, it became slightly easier under ESTA to start to evict people because there was actually a properly constituted eviction clause. So that is where we are at the moment, and that is the overview, and that has taken me half an hour. The last part at the bottom there is section 26, deals with housing, and the act that came in there to deal with the section 26 is the PI Act. So what I'm going to do now is go into the next slide. This is a list of all of the laws that are really important that we've gone through. I'm not going to delve into that too much because we simply don't have the time. And now let me go to key aspects of understanding the background. Now, the reason why I want to go to the background is because as attorneys, I do not think that you actually have the time to delve into the laws that operate before the constitutional era. You simply don't have the capacity, and I'm sure that nobody would pay you for this, particularly not your clients. So what I've done is the highlighting that you see there. Black is because things were changing. That shows that in the future something was changing. So that word will change, development will change, black will change. And there you see the laws on plural relations, and meaning black people. And the core essence of the Land Act 27 of 1913 was to make provision for purchase and leasing between blacks and other persons. And just have a look at this first clause, because that will give you an idea of how powerful this act was. It says there, from and after the commencement of this act, land outside the scheduled black areas, and of course that is the 7.5%, except with the approval of the Minister of Plural Relations, and of course that was a much later change of the name of the minister, is except with the approval, a black shall not enter into any agreement or transaction for the purchase, hire, or other acquisition from a person other than black of any such land or of any right thereto, interest, or servitude thereon. And then the next one, a person other than a black should not enter into the reciprocal agreement. Now, that is how potent these laws were, and you will see as we go through these slides how extremely powerful the British colonial administration was of South Africa. Here is the Black Administration Act, and the reason why I'm highlighting this is because the Section 1 deals with the power of the Governor General as Supreme Chief. Now, the Governor General was the equivalent of the King in South Africa. He represented the place of the king or the queen, but at that time it was a king. And it says the following: the Governor General shall be supreme chief of all blacks in the Union, and shall in respect of all blacks in any part of the Union be vested with all such rights, immunities, powers, and authorities as are and may be from time to time vested in respect of blacks in the province of Natal, because they had a separate statute for the province of Natal. Then, further on, another section which I thought is necessary to highlight: the Governor General may recognize or appoint any person as a chief of a black tribe, and may make recommendations prescribing the duties, powers, privileges, and conditions of service of chiefs so recognized or appointed, and of headmen acting chiefs and acting headmen appointed. Then, even worse, the Governor General may depose any chief so recognized or appointed. So the whole structure of tribal authority was under British colonial rule, and we are living with the consequences of that today. What has happened is that the government has tried to improve the position of tribal rule, but the problem is the position is based on a false assumption of what was originally tribal rule. And so what we have, and the criticism that is going on constantly, is that we have a type of fossilized, almost codified feature which doesn't fit the real traditional African way of life. And we are going to have to deal with it in this debate about expropriation without compensation. Two other aspects there. These are the gender biased basis from the British colonial rule. It says there in section 3, subject to the provisions of this section, a black people or tribe shall not be responsible for the personal obligations of its chief, nor shall a tribe on the ground occupied by a tribe be bound in any way whatsoever by any contract entered into or any liability incurred by the chief, unless it has been approved by the minister after having been adopted by a majority of the adult male members of the tribe present at a public meeting. So the origins of chiefs making deals at odds with the desires and the protection and the trusteeship of people living in their communal areas is not something which is new. This has existed before the Second World War. This is not something new to apartheid. This existed already in British colonial rule. And so it's really important to understand that the mess we're in today has a long pedigree, and we are going to have to untangle it. And then the last one is there: a Bantu, the definition Bantu, shall include any person who is a member of an Aboriginal race or tribe of Africa. Now, the reason why I wanted to highlight that, even those days of the colonial era, people could recognize that the black people were the Aboriginal people of this land. They said it so much in their legislation. So it's not something which is new. So when people get upset, for example, with people from the economic freedom fighters like Mandisa Mashego, she is not wrong in her assessment that, in fact, even during the colonial era, the descendants of the colonists, like me, understood that the Bantu people were of the Aboriginal race of this land. And I'll get back to that later. It becomes even more important when we start to look at the position of the Khoi and the Khoisan. Now, I have put in here parts of the Development Trust Act, and I've put in parts of the extension of council's powers, and what it was doing there was allowing the provincial councils to operate basically for the state. And here's one of the bête noire of the apartheid era, the Trespass Act, which I regret to tell you is still our law. This hasn't even been repealed. And it's quite a damning act. As you can see, it's 2,000 rand or 2 years if somebody is convicted. Now, these laws which I'm putting in here, obviously all of these PDFs will be sent to every one of the participants in this webinar. These things inform the basis of the fight that we have today. Here's the Black Laws Amendment Act, and Section 100 is to substitute the word native and derivatives thereof. So it is native, natives, and natives, obviously with the capitals, with Bantu, Bantu, and Bantu, and so on. Now, the next important act was the Subdivision of Agricultural Land Act, and that was number 70 of 1970. Now, one of the reasons why this act was needed is, as you can see, the important point for us to deal with today is that Section 3 prohibited the subdivision of agricultural land, except if there were a whole lot of controls that one went through. What had been happening is that under the Roman Dutch law, when a farmer died, generally his children would inherit. So the farm would get divided, and then it would be subdivided. And then the children's children would inherit. And after a while, the government started to get concerned that these farming units were not becoming viable. And so we have to deal with the Agricultural Act on the basis of what was worrying the white farming community at the time, and hence the act. Here's the one that deals directly with succession, and this is testamentary succession. It's Section 5. If the minister does not, in terms of Section 4, consent to the subdivision in accordance with any testamentary disposition or the intestate succession, which of course is from the Roman Dutch law, or to the vesting of an undivided share, then the executor must realize the land as an undivided share. In other words, you must get the money out of the property and it must be sold en bloc. Now, the next act inside the apartheid architecture was the Expropriation Act. Now, this act is a very important one, and the only part that I'm highlighting here is Section 12. And the reason I'm highlighting this is because it has a very direct and important aspect to deal with when we deal with expropriation without compensation under the new constitution. Look carefully at Section 12. You see the highlighted portion, open market by a willing buyer and willing seller. Willing seller, willing buyer, sorry. That is where the concept came from, which the African National Congress, I believe, in error, made as its foundation policy for the manner in which it was dealing with land restitution and in South Africa. And here lies the heart of the problem. But it's a little bit more complex than that. If you see the basis of compensation is in Section 12, I'm not going to read through this, it's long. That's the first page of it. Here's the second page. And there's the end of it to get to 13. So the point I'm making is this. The 75 Act had a very comprehensive, detailed mechanism for paying compensation based on the willing buyer, willing seller. In our current legislation and in the Constitution, we don't have that level of detail. And this is where we as lawyers are going to have to advise clients, and particularly government officials, about how to balance the right in relation to what we've already got in the Constitution. I will come back to this point later. I just want to rush through the rest of the others because I see time is marching on. Now, this is the Black Urban Areas Consolidation Act, and here was the change that was coming in again. As you see, I highlighted some of them, but not all of them. This is where apartheid was starting to fall apart, and people were realizing things were going wrong. Can you believe they had to change the word Bantu beer to sorghum beer? That is the level of control that operated in the apartheid era. Now, the Alienation of Land Act has got some interesting definitions here. Agricultural land means land which is for commercial farming operations. So, in a sense, what that does is it tries to bypass the concept of small holdings, and that is going to have impact on us on how we deal with the debate with regard to the current polemic. And look at this, here comes in the Black Communities Development Act. As you can see, it was abolished by Act 108 of 1991. And those are all the instances that have been changed later. You may happily read these at home. Let me get to our Constitution. So, in our Constitution, at section 25, we have to start at the beginning. And I know this sounds a bit silly and tautologous, but it's really important to have a good look at section 25.1. I've highlighted parts that I need you to focus on. It says there no one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. So let's go to the red highlight, property. What does that mean? Now, property, clearly in this expropriation without compensation, people are talking in the context of land. But section 25 deals with property. And as you know, property comprises movable and immovables, tangibles and intangibles. So this clause deals with all forms of property that exist in law. So the cardinal point to start from is to realize that in the land debate which is coming, people need to focus on defining immovable property and not leaving it vacant or vague as property in general. Now, if there's going to be a change, the change has to be affected by a law of general application. That means it's got to apply across the board. And no law may permit arbitrary deprivation. There's so much case law on this. It will be in the notes that I send to you, but it's not really the focus of today's webinar. The focus of today's webinar is property is not limited to land. Well, for the purposes of this webinar, we are limiting it to land. Now, here comes the expropriation part. People didn't realize that, in fact, expropriation was allowed in terms of the Constitution, and it's in the subclause 2. Property may be expropriated only in terms of law of general application. Now, that was the first part. And then the reason why I've highlighted these is because public purpose and public interest mean two different things. Public purpose is when you want to build a road or a bridge, or whether you want to do a pipeline that comes from Durban to bring petrol up to Johannesburg area, which they did a number of years ago, or whether you want to build the Gautrain. that you can expropriate for a public purpose. Public interest, that is much wider, and that goes back to the previous slide, that to later slide, sorry, um, and this section 4. Public interest includes the nation's commitment to land reform. And ladies and gentlemen, we've had this in our constitution since the 4th of February 1997. So this has been our law since 1997, and we're now in 2018, that's 21 years. So we can handle the idea of expropriation. But now, how is it going to be achieved? I'm going to have to come back to this slide in a second, because here is how you work out the compensation. Compensation is worked out in in 3. The compensation, the amount of compensation, and the time and the manner of payment must be just and equitable. And that's the linchpin of what the compensation is. But remember, I showed you that long section 12 of the 75 Act. This is all that we have in our constitution. And it is in respect of this part of the clause that the whole polemic in South Africa has exploded. And there are a whole lot of things to say about the way in which this polemic has exploded. But we as the lawyers have got to keep our cool, and we've got to be able to show that the arguments that we are putting forward for the farmers, or the arguments that we are putting forward for the people working on the farm, or the people looking for land, these have to be justified in terms of being just and equitable. And that's on the compensation area. The compensation must also reflect an equitable balance between the public interest and the interest of those affected. In other words, it cannot be arbitrary at any stage. And all the relevant circumstances, including. Now, the current use of the property is a very interesting one. Large tracts of land are owned effectively by absentee landlords. Now, I want to take you back approximately 2,000 years to understand this point. 2,000 years ago, Rome was a republic, and the republic fell when Augustus Caesar won the Battle of Actium in 31 BC, and he effectively took control of the Roman Senate. He called himself the primus inter pares, the princeps, the one who was the leader. But the Senate was kept intact, and he said to everybody that he'd restored the republic. But we now know the era of Augustus Caesar as being the commencement of the empire. And you remember from your Latin studies, those of you who did Latin, or from your Roman law studies, those of you who did Roman law, that that was the beginning of the Principate. That was the beginning of the Roman Empire. Now, the senators still had a job to do in the Senate, and they used to confer with the emperor a lot. However, by 150 years later, the emperor had all power and the Senate had very little power. And the senators owned property all over the empire. They were called latifundia. They were massive properties. The only problem is the Senate used to sit in Rome, which was convenient, and they used to earn money from all of these properties, and they used to send out chamberlains to go and look after their properties. And eventually, the emperor started to worry because he wanted to make sure that at least the senators, when they reported back on their property, had actually seen their property. And so he passed a law that if the senator hadn't been on his property in 30 years, he lost the property. Hence, that went into the Corpus Juris Civilis, and that was the origin of our law of prescription. Now, let's go back to section 25.3a, current use of the property. If a person is the owner of vast tracts plots of land, but is not using it, or is using only a part of it. There is a very good argument to be made that because there was no current use, there is no real need for a very large amount of compensation. So that is one of the arguments that can be used. The history and the acquisition of the use of the property is another. Here we deal with the land bank, particularly the way in which farms were capitalized under the apartheid system and given free loans or loans at very low interest rates. Now, that was the state then, which in effect is still here under a democratic disposition. So if in the past somebody got vast amounts of money, then why should they be paid out from the state again vast amounts of money? Now, the reason why the payment system of willing buyer and willing seller came into absolute and total disrepute happened in 2013. Many of you will remember the debacle of the payment for the Mala Mala Game Reserve. There the payment was 920 million rand plus some 78 or 85 million rand for the improvements, which pushed the Mala Mala payment in total to over R1 billion. And that payment was sent out to people who were in the Rattray family, and they did not understand the irony of being photographed in clothing that looked like the old English gentlemen of the 19th century interlopers in South Africa. It was quite astonishing. Okay, let's deal with market value of the property. There it is. Now, the market value has obviously got to be taken into account, but it's only one of the factors. So the idea that you base that willing buyer, willing seller is only one facet where the African National Congress regrettably fell short in its entire land reform program. Then the extent of direct state investment and subsidy, that's not only today, but as I said in the past. And then, of course, the purpose of the expropriation. Now, again, that's an overview. And what I want to do in this part of the overview is to come back to what's really going on in South Africa. If you look at this clause 7, this is the restitution clause. Now, I want to make some remarks about the problem with the restitution clause. The restitution clause requires proof of people who were living on particular land and that they were displaced. That part is slow and it requires to go to court. And unfortunately, even though not all lawyers specialize in this area of our law, most lawyers would recognize that the court system is slow. And it is the Achilles heel of the magnificence of the South African Constitution, that our justice systems work so slowly. The other thing, which is a really difficult thing for practitioners, is there is a constant changing of practice directives in each court. This complicates unnecessarily the life of litigants, and it increases the costs and the burdens and the hurdles and slows the whole thing down. Now, when I'm talking about restitution, where I can usually see reasonably direct evidence, what is it when you're dealing with the subsection 6, where you're dealing with the labor tenant? Now, the labor tenants, these are people who generally but not always, but generally, are not very um, literate. And so one has to wonder how the evidence is acquired to look after these people. And sometimes, and apart from those who were trapped into becoming farm workers and then, of course, lost their rights that way, those who stayed on the land, who can't prove 150 years ago, um, it requires a level of understanding of oral histories. Now, there is a very good constitutional law case, and I will, as I said, I will cite all of the case law in this, in footnotes and endnotes when I redo the typing of this webinar. But the Constitutional Court case is the Salem Party Club versus Salem Community. And Cameron, Justice Cameron, on behalf of the whole court, quoted something really dynamic from the Supreme Court of Canada, in which, in a particular case, the difficulty of orally history was recognized as follows. The difficulties with the features of oral histories is that they are tangential to the ultimate purpose of the fact-finding process at trial, the determination of historical truth. Oral history is not only concerned with historical facts, but also the values and convictions of the community it recollects. And Lamer, Chief Justice, continued and said, notwithstanding the challenges created by the use of oral histories as proof of historical facts, the laws of evidence must be adapted in order that this type of evidence can be accommodated and placed on an equal footing with the types of historical evidence that courts are familiar with, which largely consists of historical documents. Of course, people think that documents are better than oral history, unless you are a student of history, in which case you will know that the donation of Constantine took approximately 800 years before it was proved to be a complete fraud. So the importance of taking into account oral histories is already captured inside Section 30 of the Restitution Act. And when you look at Section 30, which I don't have on the screen, you will see that unfortunately our courts haven't taken it sufficiently seriously. And that is a problem. Now, let's move to the most important one, and I've left it for last because it is the most important one. This is the Section 25(5). The state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on an equitable basis. And ladies and gentlemen, this is where we as lawyers have to step up to the plate. This is where this entire debate is turning. It is the centerpiece. Let me make a general statement, and I think because it's so general, people will not be able to quibble with the generality of it. You can quibble with the facts and the figures of it, but the generality is the following. It seems profoundly unsustainable that a small minority in a country has so much wealth in the midst of so much poverty around it. So it's not a sustainable thing. Now, for those who have a sense of fairness, it's also not fair. Some of you may have heard around about 1982 a band called Midnight Oil singing Beds Are Burning. If you go and listen to the words of that, you will see that it was a song from an Australian band requiring some land to be returned to the Aboriginal original holders. The land is so hot it's 45 degrees and so on, and 45 degrees means centigrade, which is very hot. Now, we are going to have to work a way in which the land redistribution is done without a complete collapse of our constitution. We are the ones who've got to keep our cool heads. We are the ones who have got to lead not only by the example of keeping cool heads, but also by a particularly fastidious application of legal principle concerning the equity of what is going on. So, for example, Dr. Ruth Hall, you may have heard of her, she's a researcher in the field, says that there are some basic questions that need to be addressed with regard to land reform, particularly when one is looking for to enable citizens to gain access to land on an equitable basis. So she asks, for example, why are we doing land reform? In other words, are we doing land reform because the EFF has put it quite rightly on the center stage for 2019? Or are we doing land reform because we understand that in the long term, the disparity of land in this country and the ownership thereof is not sustainable? So are we doing it out of fear, or are we doing it out of a desire to get a more equitable and a more sustainable South Africa? That's an important question. One has to ask it. Then the next question that she poses is, who is this land reform for? Who's the land for? And she comes out with some really interesting and disturbing statistics. From her research, obviously done with Cousins and Claessens was part of the high-level panel under Kgalema Motlanthe, the former president. What they found is that approximately 80%, that's 80% of people who were clamoring for land, not only were they very angry they didn't have land, but were actually clamoring for land in city areas and not in rural areas. Now, if it's clamoring for land in city areas, that was then examined, and what they found is that they really do want very little land. Most people are thinking not even a hectare, and I'll come to that in a minute, the meaning of a hectare. But the main reason they want land in city areas is they want land closer to where they work, so that they could either walk to work or bicycle to work, cycle to work, or at least have some sort of transport which is reliable and not expensive. And one of the other professors in the Western Cape went along and did a particular study and worked out that people earning around about 3,000 Rand a month were spending between 1,600 and 1,800 Rand a month in transport alone. Now that is a real problem. And the people who are being booted off the farms, as we said, there were 1 million in the first from 1994 to 2004. The estimates has been another 1 million since then. Those people are living in what are euphemistically referred to as informal settlements, but they themselves refer to them as squatter camps. And they have very little hope and a lot of anger and hurt. We've got to look at some way of getting people into South African cities in a dignified manner. And here, as lawyers, we know, because some of you will have done property law and some of you will be conveyancers, you will know that when you have an area that is sparsely populated in a city and the houses are big and beautiful, that when you start to put more people and create a higher density, be it by sectional title or simply subdivisions, the property values start to go down. So now we are basically as lawyers on the horns of a dilemma. We need to bring people into the system, into the cities. But how do we do that without completely upsetting the apple cart of losing those people who are now not prepared to share, and not prepared to share evenly or even fairly, and then start to move out? These are the problems we're facing. We need to address them. The next question that um, Dr. Hall poses is, what is the outcome that we are looking for? Now, the reason why that is a good question, and the one that I want to spend a little bit of time on, if you are at my age, well over 60, most of you are well younger than that, but speak to your parents and your grandparents, they will be able to tell you of the standard layout of an apartheid town. And in short, the standard layout of an apartheid town was business and white areas in the center, and white residences near to businesses. Then, outside of that, colored and Indian as the buffers between the people farther outside, being the black people. And that was the standard setup of most of the apartheid towns. Surprise, surprise, though, Johannesburg itself doesn't strictly conform to that, because Lenasia is farther away than the southwestern townships. The southwestern townships, of course, is Soweto. So we've got to visualize and debate with all the souls that want to speak to us, particularly our clients. What sort of South Africa, what sort of cities do we want? And we do need cities that are properly cleaned, particularly city centers. And most importantly, we need to advise our clients, particularly the municipalities, that the higher the level of density, the more frequently you must employ the cleaners. And one of the biggest ironies that has happened for many years, which has had me laughing, in 1995-96, the African National Congress, technically a left-wing party, started to outsource municipal services. And as you know, in the long run, that liberal market economy is a mess, because then the workers get paid less. They don't do the work as well because there are fewer, because of the cost cutting of the person to whom it's outsourced, and basically they become labor brokers, and that system is falling down. Now, Helma Mashaba, technically the conservative of the Democratic Alliance, is now starting to insource in Johannesburg people to do security. It is not long before municipalities will realize that if they really want control and accountability of the way in which they do their jobs, which they are elected to do, that actually it is better to have these people insourced rather than outsourced. Now, we as lawyers have got to show all the clients we deal with, particularly government officials, that South Africa can work, that we can have a proper spatial planning for the cities, but we have to work together to get this sorted out, and we have to start looking at different forms of rights. Now, the different forms of rights, we know that there is a spectrum of rights. So you can have ownership, full ownership with the title deed. And on the far end, you can have ownership within a group. For example, you are part and parcel of a particular tribe living in a tribal area and properly in conformity with the customary law, and your access to land is guaranteed by virtue of your community. So we can have different types of rights. I have got some remarkable slides which I haven't managed to load onto the system, which I am going to send to you, but I'd like to And it comes from an article which I'm going to be sending out, which is a particularly um, enlightening article. It's from the South African Journal of Geomatics. Obviously, the Geomatics Act is part and parcel of all of this. And the author is Jennifer Whittle. She's from the Geomatics Division of the University of Cape Town. And her document is called A New Conceptual Model for the Continuum of Land Rights. And of course, it's based on very important work done by United Nations Habitat 2008. And I'm reading from page 14 of this particular article, which is the continuum of land rights. So if you can visualize it, on the yeah. Ladies and gentlemen, I believe that there was a technical thing at a drop at a 17:18, which is about 6 minutes ago. The first person to indicate the drop was Sipilele. Sipilele, what was the last thing that you heard, please? And I'll pick it up from there. If you could just type in. It's back, yes. What was the last thing you heard, Sipilele? If you could just tell me what was the last point that I was making, because I don't mind repeating it. I saw you said it's back. Spatial layout of towns, Penny. Thank you very much. Okay. Let me go back to. Yes. Okay, I've got that. Thank you, Sipilele. Let me just make the point again about the spatial layout of towns. The old apartheid towns had the center of business and white residential areas more or less in the center or very close to it. Outside of that were the colored and Indian areas, and these acted as a buffer to what they used to call the locations, and that is where black people lived. And the black people were the African people. Now, that spatial planning has operated in most of the towns throughout South Africa, except bizarrely in Johannesburg. In Johannesburg, Lenasia and Lenasia South are farther out than the southwestern townships. And of course, the southwestern townships was turned into an acronym in 1963, and it's called Soweto. Now, one of the features that we need as lawyers to be able to explain to our clients, particularly municipalities, and to clients generally, is that we need to have a good spatial planning, and the spatial planning does require us to allow people to get into the city centers. The ideal for people is that they should be able to either walk to work or bicycle or cycle to work, or to have metros or buses. But
30 kilometers, which is the average distance of Soweto to Johannesburg, is too far. And one needs to have more accommodation made available in the cities. And the question is, how do we do it? Now, freehold title is incredibly expensive and cannot be afforded by most people. Sectional title is expensive and cannot be afforded by most people. So there is a continuum of rights. And the best article, which I'm going to send to you on PDFs, is written by Jennifer Whittle, and it's in the South African Journal of Geomatics, Volume 3, Number 1, January 2014, and it's called A New Conceptual Model for the Continuum of Land Rights. And if you visualize what she's saying, on the left of your screen would be informal land rights, and on the right of your screen would be formal land rights, and there'd be a line between them. And then starting on the left, drop down would be perceived tenure approaches, then going slightly to the right, customary, then occupancy, and there I made the point for those who are still listening that we used to say that possession is 9 points of the law, meaning occupancy. Then there are anti-eviction laws, then there's adverse possession laws, and then there's group tenure, and then there are leases, and then there's registered freehold title. Now, in Johannesburg, it has become quite the norm to talk about Hammer Mashaba, and together with the Democratic Alliance and their alliance partners, the EFF, that they are starting to expropriate buildings that are basically owned by absentee landlords who have basically abandoned the buildings. Some of the buildings have been taken over by rentiers who then exact horrible rents to the people that they allow in. And the idea there, from a Democratic Alliance point of view, is to get these properties to be upgraded to such a state where they can be purchased again by the middle class and the upper classes, and hence the penthouse concept from coming from New York. Is that actually what South Africa needs in light of the horrendous number of people living in the informal settlements around the outskirts of the country? I must say, I think we do need genuinely to reconsider who should be going into these buildings rather than how much they can pay to get into the buildings. But that is one of the features where we as lawyers are going to have to balance this entire debate between how do we get citizens to gain access to land on an equitable basis. And so let's go back to the other. I've got 8 questions posed by Dr. Ruth Hall. What would a land reform look like in South Africa in our conceptual design for the future? So most importantly, she's saying that most people are looking actually to get better land rights or some form of secure tenure rights in cities, and then outside of the cities, that's in the peri-urban and particularly the rural areas, the EFF has made a lot of propaganda about the 35,000 commercial farms, but there doesn't seem to be a very realistic understanding of how those farms are working. And I say that with respect. I do know Dalium Profil as a colleague and a friend, and we have worked together in the past. But the reason why I worry about the EFF approach is because they are talking about the nationalization of land in a very similar manner to which the nationalization in the year 2002, effective in 2004, occurred of the mineral rights of this country. We do have a nationalization statute of all the mineral rights, which is now called the Mineral and Petroleum Development, the Mineral and Petroleum Resources Development Act, and that nationalized all of the minerals of South Africa. They now belong to the state. Whether that can be achieved directly with regard to land is what the EFF is saying. However, if one has a look at what is currently happening inside Zimbabwe, where the land reform process started in a complete mess, but has now calmed itself down and is starting to sort itself out into something quite progressive. And I say that I have cousins who live and work in Zimbabwe, so I do know that it is working. They have two systems in Zimbabwe. They have big commercial farms and they have small holdings. And the very big commercial farms were divided into two parts. Those parts being used remained commercial. Those parts that were fallow were hived off. The hived off parts were then broken up into small holdings. And those small holdings are now sufficient to allow more than subsistence farming for the people on it. Those people who were doing subsistence are now actually starting to move into sell in small markets near towns and even as far as Harare. So, in other words, if we keep an open mind to the manner in which we look at the way in which land tenure can be done on an equitable basis, we are likely to get to a much better and informed decision rather than having a sudden meltdown as happened in Zimbabwe in 1999. So the other questions that Dr. Ruth Hall has posed are the following. What would a land reformed countryside look like? Now, having just spoken about Zimbabwe and the way in which they are now getting themselves out of their difficulties, perhaps we don't need to go through that rough patch. And perhaps we, as lawyers, can propose better mechanisms to get there without all of the mayhem. She asks, would we have fewer commercial farms? Well, one of the interesting features is that in 1994, there were approximately 57,000 commercial farms in South Africa. But since then, there's been a lot of consolidation of commercial farms. So we're now down to about 35,000. So that is actually means that the commercial farms are dwindling in number. But shouldn't we then also make sure that we start to get more small holdings? Now, the last two questions that I want to pose before I stop, because I see my time is up in 2 minutes, and then we'll go to your typed questions. We are dealing here with a deep-seated and unrequited love of land from the majority of the people of this country. And the majority of this people cannot be left out of consideration forever. It's not sustainable, it's not fair, it's not equitable. Now, some schemes have been proposed on the basis that we will share the farm by giving shares in the company that owns the farm to the workers. And there was a scheme that decided that people would get a percentage in terms of the shareholding in terms of how long they'd worked on the farm. Now, one understands that people are genuine in thinking about these things, but I am a lawyer And we don't have a Share Blocks Control Act that is really strong. The Share Blocks Control Act is the closest example that I can think of to what people are doing with shares in a company. It is the company that owns the farm. The shareholders have a share in the company. The shareholders do not own the farm. So when one is thinking of using shares in a company as a mechanism for enabling citizens to gain access to land on an equitable basis, actually we're falling short. We need to be careful. It could be improved by an improvement of the Share Block Control Act. For example, when you buy a share in a Share Block Control Act, it's not like a share in a company. A share in a company, you have the right in a company, but you have no duty to the company. Whereas in a share block, you have a right in the share to go to a particular flat in the share block, but you have a duty. And your duty is you have to pay levies, and you have a duty to the other people who live in the block not to behave badly. So there is a reciprocal duty in the share block. However, one tweak of the Share Block Act, which says that the person who holds a share block share is in a position analogous to a person holding a sectional title, that would be a mechanism which could be employed, for example, in farming areas, so that people would not have shares in the company that owns the property, but shares which are themselves proof of the ownership of their patch of land, even if that patch of land is an undivided share in the whole. So, ladies and gentlemen, what I'm going to do, as I said, is type up what I've said to you today, put in all of the footnotes and references, and the reason I'm not done that now is because they are vast. And may I please ask you then to type in any questions that you've got, because we are scheduled to close at 6 o'clock, and if you have questions, I'm quite prepared to answer them. What I'm going to do now is I'm going to have a quick comfort break, and I'll be back in 2 minutes. Hello, people, I'm back. Can you hear me? Okay. Fellow, I've seen your question. It is, um, what are the rights of the family members of a labor tenant upon the latter's demise? Now, strictly speaking, they step into the shoes, inverted commas, of the person who has died, and they are entitled to those rights. The problem in practice is that they are finding it incredibly difficult to gain the proof that is required because of um, the the um, the grandparent parent link. And that is where we've had a lot of difficulties getting courts to understand that they've got to expand their vision of how the evidence is presented to them, particularly in light of Section 30 of the Restitution Act itself. And I'm just going to um, open my own computer on Section 30, um, because I think I better read it to people because it is an important section, and needs and lawyers need to know about it and to use it. It's okay. Section 30 follows a whole long line of Section 28, which had a lot of major amendments. Section 30 reads admissibility of evidence, and subsection 1 says the court may admit any evidence, including oral evidence, which it considers relevant and cogent to the matter being heard by it, whether or not such evidence would be admissible in any other court of law. And that is where our conservative approach amongst a lot of judges has let us down. Even the land claims courts sometimes has been very conservative in that. Ladies and gentlemen, are there any other questions? Because, oh yes, I see there's one popped up. Anna Marie. How do I, as a conveyancer, advise my client who is a seller who bought a property with hard-earned cash and find that there is a land claim on the property? To what amount will he be entitled, and or does he now risk being expropriated without any compensation? What is the actual procedure to resolve this with Land Affairs? Okay, now the high-level panel uh, basically convened and under the auspices of the former president, Kgalema Motlanthe, found that Land Affairs has been particularly slow in getting these matters sorted out, and that there are lots of settlements that haven't been paid up. So at the moment, the position is there is no expropriation without compensation on the cards, but most importantly, the seller must disclose to the purchaser that there is a potential land claim. Now, that means that the purchase price is going to be reduced to the point where the purchaser is prepared still to take the risk, because obviously that the land claim, if it's valid, now I say if it's valid, and is pursued and say it is a labor tenant, would become a servitude over the property. But bear in mind that it might not be successful. And so there you have the risk factor. However, if the seller does not disclose it, then that is going to be worse for the seller, because then the entire sale could be undone at a later stage and the seller could end up with the property and still having to pay the money back. Okay. Ah, Francois Albert Petersen, what will the position of financial institutions be who hold property as security? Well, let me tell you, that is the primary reason why I am not, why I'm speaking to lawyers and I want us to keep our heads. We cannot afford, in the current economic situation of South Africa, to have expropriation without compensation if it means that the financial institutions collapse. And the reason why there is a vague concern, it's not a real one because it's not going to happen, but there's a vague concern. And the vague concern is that in the private sector banking, 168 billion rand is tied up in mortgages of various sorts with regard to land. And at the moment, approximately 32 billion rand in the land bank. That would effectively wipe off 200 billion rand, and it would leave South Africa in a market similar to that of China, where all of the land belongs to the state, and then the Chinese bureaucracy parcels it back out. But the knock of 200 billion is not something that we can take lightly, certainly in light of the recent state capture, which is probably in the same order of money that has been lost. But my problem is not so much with the concept, because it's easy to understand, of nationalizing all the land. We did it with the minerals. My problem is a practical problem. How do you then get together sufficient people, administratively competent, to give people the land they want for what they want to do it? How are you going to physically have sufficient bureaucracy to carry out the nationalization of the land? That is where the entire idea from the economic freedom fighters does not make sense. It is just too onerous, and we know that our administration is already stretched. So I really don't think it will have an effect, but the effect is on the rand, which has dropped a bit, but it's not going to have a real effect because I just don't believe it's going to happen. Now there are a couple of questions that are similar. Let me. Okay, just read. All right, Magda. I have a case where a client has a person living on his land. It is not known whether he was a labor tenant for the previous owners, but he has never worked as a laborer for the current owner. But the current owner, as a fair person, allowed him to stay on the farm since becoming. Okay, now that is a classic case where we could have a very, very good response for equitable access to land. What Magda is saying is that her client has a particular piece of land and there's been somebody living on it who's not working for him, but has been there forever, for a long time. That means that her client is not using that land. It would be very easy then to afford by agreement a labor tenant status for permanent servitude over that land. He's not losing it, he's not losing it. And then there would be a level of reform on land, which is good. And that type of approach has been used, particularly in the wineland areas in the Cape. Let's see, another question has popped up here. Anna-Marie, you've asked, are you not supposed to first contact Land Affairs? We found that we get different certificates on the same property, ranging from confirming there is a land claim to no land claim. Now you've raised the same thing that former President Kgalema Motlanthe found, is that the administration inside Land Affairs is a complete mess. And it depends also on which province you're in, and it's a little bit like the mess that was going on in Johannesburg, and conveyancers will tell you here of how to get certificates before they could transfer the properties. And it goes back to the point I was making earlier. It is this basic administration which is failing, which is why I believe that it is not possible to have nationalization of the land en bloc in the same manner as the minerals. The minerals there, you are dealing with a very small class of people. You're dealing with mines, and the mines have a very good way of looking after themselves. But when you're dealing with the entire society, only the wealthy and the high connected in politics would be able to get a proper um, administration of the land they want, and the rest of the people would be left behind. And I'm not sure further how to answer your question as to what to do about the fact that there are conflicting ideas about the land. One of the ways, though, which is a practical way, which I used to use, because I did a lot of work for labor tenants and farm workers. I grew up in the Free State, so I was Afrikaans speaking. So the first thing I would do is I'd go and introduce myself to the farmer, the owner, and often would invite him to come with me to meet my clients. Now you can do it the other way around and actually establish a rapport to find out what is the real position. And then once you've found the real position, even though it's not recorded in paper, you know the factual position, then you will be in a better position to advise your client. Should I rather sell my property in advance to prevent the risk of being inappropriated without compensation? Absolutely not. That is the last thing one should do. No, the the panic selling is not the way to protect property rights. Penny Jenkins says, should all landowners who have claims against their property and which are not resolved in light of the threat of expropriation without compensation ask for the claim to be referred to the Land Claims Court for decision? That's quite a clever way to deal with it, because then it's wrapped up in law. And as you know, the problem with the whole of the Land Claims Court process is not that it doesn't work. It does work, but it works so slowly. And the old adage of justice delayed is justice denied. But here you're looking for it as a shield, not as a sword. And as a shield to take it to the Land Claims Court, that's quite a clever approach. Kholofelo, you say, if one fails on a claim of labor tenancy and they are alternatively covered as occupiers, do they also have to seek consent from the owner or person in charge if they previously did not have to acquire consent, for example, extension of dwellings, increase in livestock, and the likes? The answer, yes, they do have to ask for consent, and it is always a very good thing to ask for consent, because in that way they build up a very good rapport with the owner. If, however, they are staying exactly in the position that they were before, the case law is divided on that. Part of the case law says it is better to get the consent, but there doesn't seem to be an absolute requirement. But the nanosecond they're increasing their dwellings, increasing their livestock, they must get consent. Have I missed anybody's question? I see there's another one coming in. Okay. Oh, I did. Marlene Grease, in your experience, if there is a land claim by a labor tenant on a farm property of 930, I'm not sure if there's 930,000, 930 hectares, and the tenant used less than, say, 10 hectares for cattle and dwelling, what would the compensation be if they wouldn't take the whole farm? Now, you can't, it's cattle, okay, I get it. Let me just quickly, I missed out explaining it earlier, when the 80% that Dr. Ruth Hall had found wanted actually land in cities or access to closer accommodation to the workplace, and people were talking about not more than a hectare. Now, visualize a proper Olympic-style athletic stadium where you have the inside athletics track, where the person starting on the inside track runs right around the track for 400 meters. Now, if you're really good, you're doing it in under 45 seconds. That's people who are really good. They're sort of 11-second 100 meters. These are the sort of Dwayne Finney-Kirk style fellows. Now, that area inside that track is, if the track has been properly measured for 400 meters, it is 1 hectare and approximately 70 square meters. So a hectare is inside the inside track. Another way of saying it is a hectare is about the size of a standard rugby football ground, football terrain, including the try areas. So if somebody has 930 hectares and the other people are only using 10 hectares, it would be completely wrong to expropriate the entire farm. The proper way to deal with it there would be either to put the servitude on the 10 hectares or to subdivide and allow the hectares to go off to small holding, which is basically what they've been doing in Zimbabwe. Right. I see all of you are still listening. I sincerely hope that you found this webinar enlightening and helpful. What I would like to do, and I repeat, I'm going to get the recording of this. I'm going to get it transcribed. I'm going to correct all of the silly little ums and ahs, and then I'm going to send it out to all of the participants. I believe originally you were 100 strong at the seminar. Today it seems to about 30-ish, but we'll send it out to all of the people in writing, but it won't be before the end of September. The last question that I see here is, when it comes to settling a land claim, how does one, as the responsible landowner, balance in the settlement the claimants, the Ester claimants, and the labor tenants in the set? That is a brilliant question. Okay, the labor tenants have a higher level of right in terms of the way in which Western law would look at the balance of these rights. Their right is a slightly stronger one than the Ester claimant. So technically, on the way in which Western situation would assess these rights, is that the labor tenant, if he's being bought out, would get more than the Ester claimant. However, when one is looking at the actual way in which we would like an equitable redress to be done inside South Africa, then the ideal way would be to pay them out on a level, on a proportionate basis, equal in, say, 10 labor tenants, 5 Ester claimants, 15, then you divide the amount by 15 and each person gets an equitable share. But that will depend on which system of law you're using. The system of law that we've written our constitution in is, excuse me, the Western system, but it does make provision to apply a more ancient system. And one of the things that I need to point out concerning the more ancient system is that the concept of customary law was set out in Shulubana's case, and I will send you the reference, and Justice van der Westhuizen said at paragraph 55, it's a very interesting statement here, customary law must be permitted to develop, and the inquiry must be rooted in contemporary practice of the community in question. Section 211(2) of the Constitution requires this. The legal status of customary law norms cannot depend simply on their having been consistently applied in the past, because that is a test which in any development must necessarily fail. Development implies some departure from the past practice. A rule that requires absolute consistency with past practice before a court will recognize the existence of a customary norm would therefore prevent the recognition of new developments in customary law. In other words, what the judge is saying is, when we're looking at customary law, we don't look at a codified system in the past and call it custom. It's customary law, it's a living law, it changes all the time. So we, in our first world conceptualization of the Constitution, must at the same time be able to balance in a completely different, more ancient system than our Constitution, and that is where we will gain this equitable access to land. And it's not an easy job, and that's why we are lawyers. And the last question that Anna-Marie posed, would a solution not be to subdivide into small portions again? Yes, it would. Ideally, it should follow the de facto current practice in Zimbabwe, where large commercial units are kept intact, and the fallow land and the land not being used on those commercial units, that part is hived off to the small holdings, and in that way we would solve a lot of the problem in the rural areas, bearing in mind that it seems that only 20% of our problem is in the rural areas and 80% of our problem lies in the city areas. Now, I've left out one last slide that I'm going to have to go to, and it is this one. This is the adequate housing one, and as you can see, we have to achieve the progressive realization of this right, and that is the origin of the PI Act, and everybody knows the PI Act. And the PI Act and Section 26 on housing, these must be seen to mesh into the land part of the debate under the property clause. And so, to highlight again Section 25(1), when we're talking about expropriation without compensation, we're not talking about property in its entirety. The real debate is about immovable property and how do we get the 80% of people who need decent homes in the cities into Section 26. And that, ladies and gentlemen, is going to be the last thing that I have to say today. Thank you very much for all of you staying so long to listen. I'm astonished. I'm really delighted. I was thinking some people would have bailed out earlier, but you haven't, and that's very nice of you. Thank you.